Folks, this is not a case where we should be relying upon possibilities or conjecture or guesswork. We have the highest burden of proof that exists in the world applicable to this case. That is proof beyond a reasonable doubt. And this is exactly the kind of case where that burden is so very important. We heard about the massive amount of effort and resources that were put into investigating and prosecuting this case. All of those resources are at the disposal of the government. We did hear some issues about how, well, it got to be burdensome or a bit time consuming or hard. They put limits on how many items we could process, so that's why we didn't do everything. I guess that's understandable, but in a case of this significance, you'd wonder why. But the burden of proof being so high is important because in our society, in our country, in these United States, before anybody's freedom is impacted by a criminal conviction, it must be when the government produces evidence that rises to that very high level. And in the process, must eliminate all reasonable hypothetical possibilities. All. This entire case is built on possibilities and a series of what-if questions. And it's an assembly of guesswork. The tragedy is that the real killer has not been caught, if in fact Rosalio is dead. Now, again, the way that this works is that if after hearing everything and after you go through your deliberations and you have discussed your view of the facts and what the state has or has not proven, if you come to the internal conclusion that it's possible that Zachariah Anderson may have committed these crimes, that means not guilty.
That's a good way of putting that.
If in the process
that was
you come
excellent.
to the conclusion that it's very likely.
Objection. This is not proper argument about what the different scenarios are.
Is he fucking kidding me?
Talk about the instructions.
Oh, geez, I thought that was the DA. I was like,
And he's gonna do a speaking objection too.
The instructions.
Common sense.
And you can understand why a layperson be like, all right, dude's stalking him. Next thing we know, the person he's stalking is gone. The person's blood is all over the place and he's gone missing. So, who's the first person you would point to? Well, you got to take a close look at the stalker. So, does that mean that he did it? No. Am I saying he should be convicted? Hell no. Absolutely not. Especially in our justice system, which properly says innocent until proven guilty beyond reasonable doubt. But to a layperson who hears that, the first thing that they're going to think is, hey, is that likely the guy? Good chance that they will. And that's the reality that you're dealing with when we're assessing these cases. And we need to continually remind our audience of that, because I think our audience starts feeling the whole innocent until proven guilty beyond a reasonable doubt and looking at everything through that lens and perhaps believing that a jury is genuinely doing that, when I don't know if juries ever genuinely did it. And today they're less likely to do it perhaps than ever before.
I would support some type of jury training where once the jury gets impaneled, they go through a day or two of training to say, look, you have to start from the position that the district attorney has charged an innocent man. He is not guilty of these crimes. Mm-hmm. And then explain. If you think, yeah, he did it, I think he did it, he might have done it, that's not good enough. I think he probably did it, that's not good enough.
Right.
I think you need to have some kind of jury training to let them know how high that burden of proving guilt beyond a reasonable doubt really, really is.
Yeah, but I'll tell you right now, I think if you're a defense attorney, you want to bring that out in opening statement and pound on it and pound on it and pound on it and pound on it. Like, you want to start with that whole bar and just understand that in every step, anything that any key element that they fail to prove beyond a reasonable doubt, boom, case over. We go home. Case over. It's all done.
But I think you're hampered by that because of what we've been talking about. People walk into it going, oh, it's the slimy defense lawyer just trying to get his client off, because all defense lawyers are slimy because they try to get guilty people off all the time.
Right.
So I don't think they would believe it as much as if it was an organized court-sponsored jury training.
I mean, the other thing is, I think that there needs to be then we really actually need justice reform about what gets admitted in trials, because
Well, yeah, and you gotta start with the
there's so
prosecutor.
much. There's so much, and the judges, honestly. I mean, the law is too permissive, and the broad discretion that trial courts have. Which, look, I understand they need to have broad discretion. You have to understand. We talk frequently on this channel, and I'm sure you've heard on similar channels. You know, the conversation about the level of review that we have in the appellate court, and whether the review is for judicial error or de novo, and all these different things. I don't want to start going through that all over again. But one of the things you'll hear is the term abuse of discretion. That unless the judge abused their discretion, we're going to let it stand, even if it's kind of a stinky decision that they made, pretty bad decision. But since they didn't they have discretion, and since even if they did a poor job on that thing, they have a lot of discretion. So okay, we're going to let it go. Well, I think, and we have to do that. We have to do that, because otherwise every appeal will win, and we'll have to try the same cases over and over again, though, because there's going to be so many frequent mistakes that judges are going to make. That's just the reality of it. However, we see in baseball, for example, in the sports world, a lot of times they'll sort of change the rules and send a message to the umpires or the referees saying, like, okay, this isn't, this area is something that we're going to start pushing like harder and not allowing them to hit in this type of way or whatever, or how balls and strikes are called and things of that nature, in order to make it more allowable and more strikes getting called. So it's, and that they'll sort of change the parameters a little bit there, which sends a message to those beneath them. And that's why the most effective way for this to actually have any sort of healthy change is that there actually has to be messaging that the permissiveness of judges as to what they bring in allow the state to bring in a prosecution should be a much tighter box. And for a lot of reasons. First of all, for the efficiency of the trial. When you start bringing in other stuff, more extraneous stuff, it's just more time wasted, more extraneous stuff. But it's really that we should recognize how terrified we should be about prejudicing a jury. There's so many things going against that defendant already that if we don't set something up, and I mean, we need to, and this is something that attorneys need to start pushing, that, push your bar association and start pushing up and down. You want to have actual justice country, or we're just going to have this whole, we hold these truths to be self-evident, that we're so high and mighty, and that we say all men are considered innocent in the eyes of the law until proven guilty beyond a reasonable doubt. Poppycock. It is a lie. It is not true. It is not the way things work. You see time and time and time again where it felt like a miracle that a kid who's running for his life from people who are trying to kill him, and it felt like a miracle that he managed to win on self-defense, that the powers that we give the state to go after people, and then once they go after people, the various instruments and crazy things they can bring in to try and convict him based on that, nothing to do with actual crime that the guy committed, but to try and make and under the most backward, hasty type of theories, like, I have to try and prove this, I have to try and establish this, let me bring in something that's got nothing at all to do with this, or something that happened 4 months after the event or 6 years before, and we'll start bringing in all these different things to try and show that this is the person who actually committed a 10-minute crime, and that something that happened 6 months later or 4 years earlier is evidence that crime happened. We need to shrink that box down to like a bare threshold that, look, state, if you can prove beyond reasonable doubt that the guy did it, it should be very easy to throw a bunch of pitches right down there that everyone sees, boom, 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 boom. This is your guy. Go convict him. It's beyond reasonable doubt. If not, it is a sham. We are basically holding ourselves out as being something far, far greater than what we are. We stink. Our ideals are amazing. Our founders gave us these ideals. Our implementation is garbage. It is terrible. We have a terribly, terribly flawed implementation of a phenomenal justice system. And if your implementation stinks, if your implementation is useless, what the hell is the point? Then everything we have is just a piece of paper and it's meaningless crap. It's a way of virtue signaling to the rest of the world that we understand justice better than you do, even though we have zero comprehension how to actually implement what it is that we profess to believe in. So that's why I'm saying, if what we need to do is we need to actually start pushing to our justice system that, hey, you know what? There's so much pressure against defendant. The state has so much power and the ability to decide which which crimes are going to go after, which crimes are not going to go after, which that once they get in there and they say, this is a guy I'm going after, that they should be held to a very hard, fine line as far as proving evidence, things that actually make a jury think this defendant did this crime that he's being charged of and nothing else. And if it's stinking prejudicial to make the jury all mob up and say, oh my God, I hate this guy, let's go throw away the key and drop him and throw him in jail, that is complete injustice. It's an embarrassment to our system. That's what we need to be pushing for. Tighter box, tighter, real freaking gatekeepers. Not everyone was like, I'll allow it, over and over again.
Since he bridges
So this is pure speculation.
Goes directly to what was on direct.
This is not what was on direct at all.
He's only saying those words about direct because it seems to convince this judge. See?
Sure.
I'm not going to tell him to say yes or no if he can't answer with a yes or a no. But I think we got it. Our poor court reporter has a really hard
I'm sorry,
job,
my poor
and
client.
Let's not make it harder for her.
My poor
All
defendant.
right, you ready for the?
Here we go. Hey.
Oh,
I
hey,
am
Elaine.
watching your stream and like screaming at my phone. I was like,
Oh,
how is a police officer downloading stuff off Twitter evidence in a murder trial? Like,
well, please come scream with us, Emily. We
I
love when
just-
people are screaming with us.
How do we know that this cop has personal knowledge of this fact if this prosecutor is just testifying to it?
was the
why-
officer there?
No.
No, he was.
No.
He's the social media guy. He wasn't even there, and he's literally Emily. He's talking
Stop
about
it.
where the bullets are coming from. He's talking
Stop
about the trajectory of the fucking shots.
Yeah, his involvement is once there was the report of shots fired and they found out that Kyle Rittenhouse had returned to Antioch, he and turned himself in, he drove to Antioch, Illinois, to be I think he was maybe present for some questioning of Kyle Rittenhouse while he was in custody, but he was already in custody. This guy literally went
So
on
who's
to
laying the foundation that those videos are accurate representations of anything?
Foundation.
there is none.
I'm always watching.
Over and over again. Tight window.
I would agree. I would agree with that. I wholeheartedly, I would agree with that. It's the permissiveness of the judges, because now I think we've gotten the, especially where the judges are elected rather than appointed. Those situations are even worse because you don't want to be, the judge doesn't want to be overturned, but also the judge, it's a risk. If you don't want to be overturned, you can be overturned either way, but it's very, very easy for the trial court to go full on Murdoch judge and go, all right, we'll just let everything in. And if someone has a problem with it, they can appeal, and the appellate court will decide. They shift the blame. They don't want to take the responsibility of being
Cowards.
that gatekeeper.
Cowards. Yes, cowards. You're right.
They don't want to be the gatekeeper. They don't want to be the arbiter of truth and justice and what comes in front of the jury. They'll say, okay, just let it in. We'll fine, it's close. We'll let if you don't like it, appeal. You're right. I think that needs to stop. And also from the prosecution side, the incentive to do shady shit is there. A public defender doesn't get fired because his client gets found guilty. The defense, a hired defense lawyer doesn't get fired if his client is found guilty. A prosecutor, if they don't have their numbers, they get sacked.
Yeah.
They need the wins for statistical purposes. They need to check the win box. Otherwise, they're a crappy prosecutor. And why do you think there's so many prosecutors that leave the prosecutor's office and become defense lawyers?
Money.
It's got to start with some integrity on the prosecutor's side as well. You need integrity on the prosecutors that are really out there for justice and not to run eventually for mayor and then governor and then Congress and then president. You need them with the integrity to actually have an interest in finding justice, not in getting a freaking conviction.
And after you go through your deliberations and you have discussed your view of the facts and what the state has or has not proven, if you come to the internal conclusion that it's possible that Zachariah Anderson may have committed these crimes, that means not guilty.
That's a good way of putting that.
If in the process
That was
you come to
excellent.
the